Be careful of tricks in mergers and acquisitions transactions, beyond declarations and guarantees. In the world of mergers and acquisitions, negotiating the annex of declarations and guarantees is crucial to protect the buyer from hidden risks. However, even if you think you have limited the risk, there are other legal figures that can circumvent those limits and expose your investment. Today, we are going to analyze 3 of these figures and how to protect yourself from them. First, knowledge clauses. These clauses limit the seller's liability to what is not known, meaning that if something arises during due diligence, the seller could argue that it was already known and therefore is not liable. The key here is to demand that the seller be liable for both what is known and what is not known. This way, you ensure that the seller takes responsibility for any contingency, regardless of whether it was disclosed or not during due diligence. Second, specific indemnities. These clauses are used to cover specific contingencies of special relevance, such as tax or labor issues. The problem is that it is often attempted that these indemnities are not subject to quantitative limits, which could expose the seller to unlimited liability. It is essential to negotiate clear quantitative limits for specific indemnities, just as is done with general representations and warranties. This protects the seller from disproportionate claims and ensures a fair distribution of risk. Third, limitation of liability clauses. These clauses establish the maximum liability of the seller, whether it is a percentage of the sale price, 100% of the price received, or in some cases, unlimited liability. While it is common to establish a limit of liability, it is important that this is reasonable and proportional to the risk assumed. Unlimited liability, or an excessively high percentage of the sale price, may be unacceptable. In short, to protect yourself from tricks in M&A transactions, remember, demand that the seller be liable for what is known and what is not known. Negotiate quantitative limits for specific indemnities. Set reasonable and proportional limits of liability. At ILP Abogados, we have expert lawyers in mergers and acquisitions who will help you identify and mitigate these risks. Contact us and ensure the success of your next transaction. Focus your inquiries with our AIs, Savvy and Atenea, or contact us at ilpabogados.com and ilpstartup.com.